the aggrieved party had approached this court in an appeal registered as RFA number 7 of 2025, wherein this court, by the order dated 06/03/2025, had remanded the matter back to the trial court with the direction to frame a preliminary issue on the point of limitation. Full stop. In the meantime, there was a transfer and posting of the judicial officers, and this case on being endorsed to the Court of Civil Judge within brackets senior division close bracket dash 6. Now, in the meantime, this case was endorsed to civil judge so and so, okay, instead of being. So the learned counsel submits that the present civil judge within brackets senior division dash 6 happens to be a close relative, is it, of the present counsel, who is the counsel for the defendant number one in the civil suit number 30 of 2022. Full stop. Therefore, it would be in the interest of justice if the said matter was transferred to any other court having the jurisdiction to try the matter. Full stop. Notice be issued to the respondents. Then Mr. Bila Ramena, learned counsel for the respondent, accepts notice. Full stop. No need to issue formal notice.
Under respondent number 1 and 2 only.
Okay, 1 and 2.
The rest state.
Accepts notice on behalf of Mr. Bila, accept notice behalf of respondent number 1 and 2, and Mr. Samuel L. Sangte accepts notice on behalf of respondent number
3 to 7.
3 to 7. Since all the respondents are duly represented, no need to issue any formal notice. Stop. The learned counsel for the respondents submit that they will not be filing any written objection to the transfer petition made by the petitioner. Full stop. In view of the above, this court finds it fit to dispose of the transfer petition, finding that it would be in the best interest, in the interest of justice if the matter is not tried by the learned civil judge dash 6, is it? 6. 6, and being related to one of the counsels of one of the parties. Accordingly, the said civil suit number so and so, civil suit number 30 of 2022 stands transferred to
Civil Judge Senior Division 1.
okay, senior civil judge, senior division 1, Aizol. Okay. Yes, then transfer petition number 1 of 2025 that stands disposed as above. Yes.
So pledge.
Item 2.
Yes.
My lord, my case is regarding that I was being awarded contract under NABAT RIDF 24 and 25 on 4/25/20 January
Okay, this is criminal.
2021.
Yes.
And award number 20, and Nabat RIDF 24 was awarded on 30/8/2020. Then after completion of the contract work, then the department had issued completion certificate. It is in page 114. This is the completion certificate for Nabat 24, 25, and in the second para,
Okay. It is against which judgment, which order? The instant,
22/7/2024.
where's that?
It is in page 205.
So the instant writ petition criminal is filed against an order dated, okay, where is it? Page
205.
205. I think we'll be able to understand better if we look at the order. Yes, 205. So you agreed with this order. What's wrong with this order?
This is an application filed under 451 CRPC filed by Superintendent of Police SCB, Mizoram for freezing of security deposit of 2.5% from the running bill amounting to 87,49,893 in respect of the work under Nabat.
Okay, so an application was filed
Yes, my
for
lord.
freezing of the security deposit. is
Yes,
it?
my lord.
Okay, this is the application, and the court, what did the court do?
The
It
court,
freezed your account, is it?
no security deposit.
Okay, it
which-
freezed the security deposit, yes.
Yes, freeze my securities in the deposit, which was in due to be released to me.
Okay,
Then in
so
my,
what are your grounds in your writ
my grounds
petition?
is,
That you were not heard? Is it?
yes, at the time,
You were not given an opportunity for fair hearing?
yes,
the
application
time.
date is 2nd July 2024, and on the same date they disposed the matter.
Okay.
And they did not give any opportunity of being heard. That is my first point. And my second point is completion certificate was already issued to me. as
Okay,
they-
where's that?
It is in page 114. In the second line, the construction works were executed as per technical specification requirements and quality of work is found to be satisfactory. After they had, after they did not find any damage or any defects in my construction work, they had been issued this completion certificate to me. Then after, as per the tender documents, it is in page, tender documents is starting in page 32, and I would like to mention clause 21, and it is in page 40.
Page
40.
40. Yes,
This is the security clause, and in the second para, can I read out, my lord? The security deposit will be released after 8 months of the date of the issue of the final contract completion certificate. Completion certificate for Nabat 25 was issued on 16/11/2022. Then counting from 16/11/2022, 8 months will be lapsed on September 2023, August 2023. Then my security was freezed on 2nd July 2024, which was very
was
very much
freezed.
in due.
okay, will you show notice? Who have you made the party? Who are the parties?
Then
Yes, Your Lordship, the state respondent is in respondent number 3, respondent number 1 to 3, 5, and 6.
I mean, I'm just seeing the SP has to be made a party and he is, so fine, yeah. Because he's the one who made the application, isn't it?
Yes, my lord.
Yes. Issue notice, let's see. Heard Mrs. Jacinta so-and-so, learned counsel for the petitioner, who has filed the instant petition under Article 226 of the Constitution of India, challenging the legality of the order dated 02/07/2024, passed by the Court of Special Judge, PC Act, ISOL, in criminal misapplication number 19 of 2024, arising out of ACB PS case number 1/2024, dated 11/03/2024. As the learned special judge had freezed and directed not to release the security deposit of 2.5% from the running bill amounting to 87,49,893 in respect of the works under NABARD dash RIDF, all in capital. Okay. 24 will be in Roman 24, till finalization of the case.
My Lord, 24 and 25. There is a two contract works.
I'm looking at the order. Are there two orders?
No, only one order.
Then 208, page 208.
Yes, this is only the order which they issued by the special court.
So isn't
But it include NABARD RIDF 25 also.
where's that? Where's 25? Where's 25 mentioned?
In the order, it is
If
not
this-
mentioned, but
if it's not mentioned, then how can we go beyond the order? Anyways, let's look at the order first. Till the finalization of the case, which is pending in the court. Good stuff. Now that's order dated 02/07/2020. Now where's the 25?
25, the amount is included in this order, but only mentioning 24 only.
So then it's the order we have to read, isn't it? We can't go beyond that. So the order has freezed only 24. So the 25, though, I don't think that's an issue here then. Anyways, have a look at it. Have you mentioned 25 somewhere in your writ petition?
Yes, it is in my petition. It is everywhere it is written.
Okay, the learned counsel submits that even though the impugned order had mentioned only NABARD, NABARD, okay, RIDF 24. However, the amount under NABARD RIDF 25 has also been freezed. Full stop. The learned counsel further submits that the completion certificate for the works done by the petitioner was also issued on 16/11/2022, and therefore, in terms of the tender document, which para?
Clause 21. It is in page 40.
Okay, para 21, she is entitled to the security to the 2.5% of the security deposit made by her. Full stop. Issue notice to the respondents. Ms. Vanesiami accepts notice on behalf of respondents number
1 to 3, 1 to 3,
1 to
5
3
and 6.
and
5 and 6.
5 and 6.
Respondent number 4 is Lok Ayuta, my lord.
Notice be duly issued to respondent number 5 through
Number 4.
Number 4.
number 4, okay, through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Much obliged.
Why have you made Lokayukta a party?
Because the case was arising out of Mizoram Lokayekta.
But what do they have to do? Anyways, let's see. You have made them a party, let them decide.
That's my lord.
Item 3.
Please, Lordship.
Yes.
And this is again the case of a cyber crime, my lord, where the bank officials in their personal name have been dragged into the litigation. My lord. If your lordship may come to the order of the learned court, my lord, at page 46. Your lordship may see I'm the petitioner number 1, my lord. I'm the cluster head of the bank. I'm working in the HDFC bank. I'm the cluster head, and my role is to look after the business and the all administrative in the whole state of Mizoram, my lord. And I've been made the personally accused in the complaint case. And the operative portion, my lordship may come to para 6 at page 47, my lord. The fix so and so for appearance of the accused person in person and hearing for the purpose of taking cognizance of the offense against the accused. Now here, my lord, para 7. In the meantime, the accused persons, that is the petitioner, so and so manager, branch manager in searchip, are hereby ordered to unfreeze the complainant bank account bearing number so and so maintained in the HDFC Bank Limited Searchip branch immediately without delay, if frozen without prior intimation of prima facie case or prima facie against the complainant for the purpose of ensuring that no injury or further hardship is caused to the complainant any longer against his constitutional right. My lord, here, my lord, what happened? The freezing of the account of the respondent number 3 was done because there was a cybercrime complaint lodged by the South Delhi police, which there's an acknowledgement has been there in the MHA portal, which your lordship may find at page 34. To cybercrime complaints against the, my lord, respondent number 3. Then if your lordship may come to the first one, my lord, account credited to HDFC Bank. As your lordship got it. This is the disputed amount, 2 lakhs and 10,000. Well, this account number of respondent number 3 was reported. And accordingly, well, there's also another order from the court in New Delhi to,
Where's that?
well, that, my lord, your lordship may come at page 43. And from the Chief Judicial Magistrate, Southeast District Circuit, New Delhi. Page 43.
Wait, this page 46,
Well, 46 is the order of the court below in Aizawl.
but this 46,
My lord.
what, yes, I noticed something, wait, yes. Now, 46, para 1, okay, para 1, where's the in-between? The next page is Constitution of India, taking cognizance of and, then here comes Constitution of India. Have the whole document, isn't it?
The order, my lord. Sorry, my lord. Because it was printed in both sides, that must have missed. And this is the order, my lord.
Taking cognizance of and Constitution of India cannot make any sense. That's what I just noticed when you read.
My lord. And the complaint petition, if lordship will find it page 25, my lord.
25. The full order is there?
My lord, not my full order, my lord, if I may peruse, my lord, here's the full order.
So when you have prayed for quashing of this order,
My lord.
the complete, this thing should be there, isn't it?
My lord, the complaint, my lord, is there at, my lord, page 25, my lord.
But you have basically approached this court for setting aside of this order dated 06/05/2025, is it?
My lord.
Then have the, full judgment, order dated 06/05/2025 available. Otherwise, the court cannot accept this.
My lord, if I may peruse the order, my lord.
In between, it's gone. Isn't it?
My lord.
So you take this back, saying that there are some documents that are missing and to furnish the proper. Otherwise, then the pagination will also be completely different again if there's a page which is inserted in between, isn't it?
My lord, temporary.
Because this is the main order which the court has to peruse and see whether there are any grounds for setting aside this order. And what is page 25?
But 25 is a complaint petition, my lord. In the complaint petition under section 10, for taking cognizance, when I have the prayer, my lord, lordship may come at page 29.
Anyway, you make the corrections first, and then we'll list it on Monday then.
Well, in the meantime, my lord, the court is, the matter is fixed today, my lord, in the,
But you should have been more diligent,
my lord,
isn't it?
yes, my lord, if I may, if you may,
Because if you now insert another page in between, how many pages will it
Only
be?
one
One or two pages?
my lord, if I
And
may-
then the vegetation in between after that will also have to be changed, the whole thing.
well, if I peruse the order, I have the order, full order here.
You have the order, but you should have included it here
Well, that's-
properly,
that's-
isn't
but that's
it?
not but that's on
Anyways,
my part, my lord.
You have come before the High Court, those little careless mistake, and it's the main order. If it was some other irrelevant order, I could have just, okay, excused. But this is the main order which you are aggrieved with, isn't it? And then the pages in between are missing. That's not done. Anyway, heard Mr.
M. Smith.
M. Smith, learned counsel for the petitioner, who submits that in the petition filed by the petitioner, there are certain pages missing from the impugned order against which the instant a petition has been filed. He has therefore prayed that he may be allowed to make the to rectify the mistake by filing the complete or impugned order dated 06/05/2025. Praise aloud. Necessary documents to be enclosed. And okay, documents to be enclosed. List. When's Monday? On
26th.
26th. 26/5/2025. Yes, check what you have filed before the court.
I'm sorry.
We're not making you withdraw, we're just giving you a chance to make the correction.
Obliged.
Item 25. Sorry about that.
My lord, in this writ petition, I have challenged the election of the respondent number 6 as a member of the Mara Autonomous District Council and his subsequent appointment as a chief executive member of the MADC on the grounds that he lacks the qualification to be elected as a member of the district council, my lord. As per Rule 10 of the MADC Constitution and conduct
So
of
how are you affected? This is an application under 226 of the Constitution.
my lord.
How is your fundamental right affected?
I'm affected in a sense that, my lord, I'm one of the voters in the MADC. And
Voters?
One of the voter in the MADC, my lord. And my party has also fielded a candidate in the constituency, my lord, wherein the respondent number 6 was elected, my lord.
So how is your right to be affected? Should it be 226 or 227?
I've come by way of 226, my lord.
But how is your right affected? But
Mostly
you're a
on
voter.
seeking for a writ of quo warranto, my lord. Because as per Rule 10 of the MADC CCB rules, my lord, a member should be a permanent resident of the MADC by way of birth or by way of descent. But here in the respondent number 6 had 3 different place of birth, my lord, as per the documents available on record, my lord. Wherein one of the place
When
of,
was he elected?
in the 2022, my lord. 5/5/2022, my lord. That is the date of election. And results was declared on 10/5/2022, my lord.
And what is the reason for delay? Couldn't you come
Reason
before
for
the
delay is
court a
the
little bit before
belated
that?
knowledge, my lord, because I came to know about this through RTI only in the month of August 2024, my lord.
Anyway, we'll issue notice, let's see.
My lord.
Whether it's appropriate also under 226, okay, a writ under quo warranto. Let's see. So you're saying this person is from which place?
He was born in Myanmar, my lord. As per his documents, my lord, he have 3 places of birth, my lord. One of which is in Myanmar, my lord, as per my knowledge. I have made a table at page 13, my lord.
You see, if this was discovered a bit earlier, this matter could have been placed before the election officer or whoever is there
That's true, my lord.
and
But
not
I-
come to the court.
That's true. I have obtained the RTI only last year, my lord. That's why.
Because election matters, there's the authority to look into it.
That's true, my lord. But that does not oust the jurisdiction of this honorable court under 226 also, my lord. I have some authorities, my lord.
Anyway, we'll issue notice, let's see. Heard Mr. Thiang Lima, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ against the writ to the respondents on the grounds that the respondent number what?
6.
The respondent number 6 was declared elected from 01 dash Tokalo constituency in the 12th Mara Autonomous District Council General Election, 2022. In respect of the 2022 held on 05/05/2022. Full stop. Thereafter, the respondent number 6 was appointed as Chief Executive Member of Mara Autonomous District Council with effect from 21/12/2022. Full stop. The Learned Council submits that the petitioner belatedly came to know that the respondent number 6 had 3 different places of birth as per the documents available which he had obtained from RTI.
My lord.
And submits that the the respondent number 6 was actually born from Thai Shatla, is it?
I believe.
Thai Shatla,
Yeah, Shatla.
which is a village within Paletua Township in Chin State, Myanmar. The spellings, you look at this thing, okay? It's in the synopsis. Good stuff. As such, his election as a member of the Mara Autonomous District Council is liable to be declared void and illegal. Yes, notice be issued to the respondents. Ms. Linda L. Fumble accepts notice on behalf of respondents number
1 and 2.
1 and 2. Notice be issued to the remaining respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Requisite copies of the writ petition to be duly furnished to the Learned Council for respondent number 1 and 2. Yes.
I'm obliged.
Item 5.
Yes.
This petition is filed in view of reply received from the respondent number 3. Respondent number 3 is.
Qualification.
Yes, yes.
As mentioned in these, is
Yes,
it?
we have been.
1, 4, and 6.
Yes.
And
1, 4, 3. 1, 4.
why don't you say 1, 3 instead of 1,
3,
4?
4,
Ah, 1, 3, 4,
6.
6.
Yes.
Then it's easier. 1, 4, 3, then I have to come back, isn't it? Yes. 1, 3, 4, and 6.
Yes.
Okay. Then in which column is your pay mentioned? Remuneration.
Yes, column is 4th column. Unit rate per specialist as per qualification.
So you're saying unit rate is the remuneration
Yes.
to be given to you, is it?
Yes. This sanction was made by the respondent number 1 in accordance with
Who is respondent number 1?
Secretary Ministry of number 5 and respondent number 3.
Okay, 5 and 3 are the state.
Yes.
State.
2 also. 2 is Chief Secretary. He is
Okay, the state
overall.
government is not giving you the remuneration as released by the respondent number 1. That's your case.
Yes.
Okay, we'll issue notice and let's see what do they have to say. heard Mr. Lalram Kluanga, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ or direction to the respondents with regards to the remuneration given to them. Full stop. The new para. The learned counsel for the petitioner submits that the petitioners were engaged as to the post, instead of were engaged to the post of geographical information system expert, comma, social development specialist, comma, training coordinator and research and training coordinator respectively. Okay, say petitioners number 1 to 5 in the beginning. Okay, were engaged as, then the said post respectively. Okay. The appointment was under the, within capitals, RAY/PRU, comma, centrally sponsored scheme, financed by respondent number 1. Full stop. The petitioners joined their post in the month of June 2012 on contract basis by the notification dated 20/06/2012. Full stop. The petitioners were initially engaged on fixed remuneration of rupees 35,000 per month, which was revised by the government from time to time, and as on today they are paid only rupees 50,000 per month, whereas the remuneration entitled to them is rupees 85,000 as per the funds released for the project by the Ministry of Housing and Urban Poverty Elevation, dated 10/08/2016. Stop. Aggrieved for being paid the amount less than what was sanctioned, the instant writ petition has been filed. Stop. Notice be issued to the respondents. Then Ms. Vane Isyami, learned government advocate, accepts notice on behalf of respondents number 2 to 5, while Ms. Zairam Sangpui accepts notice on behalf of respondent number 1. No need to issue a formal notice. Requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents. List after 3 weeks.
Admission item 6.
My lord, as per the last court order, I was trying to raise my client. I was trying to contact my client and I could not receive that. And may please be given 1 more week.
Okay.
Lordship, I seek the opinion of my client. However, Lordship, she is not willing to refer the matter to the Lok Adalat because the situation is very tense, Your Lordship. And when the interim order was passed itself, as soon as the petitioner received the order, He ran away with the child. And with the assistance of the police, we can now take the custody of the child. And Lordship, the next
So who is the child with now? Child is kept with the mother or
with the
father?
mother.
With the mother.
You're the mother.
I'm the mother, Lordship. He ran away with the child, and then with the assistance of the police, we can take the
So
custody.
father wants a child. Is it a son or a daughter?
Son.
Son.
Anyway, my lord, as per the last court order, it is required to seek my client's opinion. Then how much my client can impose in this case or
Okay,
not.
see, the maintainability of the instant writ petition is also questionable. Why have you come in under 226 of the Constitution? The guardianship was given to the mother.
No, Lordship, it's pending matter.
It's a pending matter.
It's only interim order, interim custody,
Then how
Lordship.
can it come under 226 of the Constitution?
No, see, whether
Interim order.
if there is a amicable settlement upon this case, then
Okay, so you talk to your client. If he doesn't want to pursue the matter, leave it. See, the child is how old?
only 9 months.
9 months. Then
Yes.
leave it.
Then
Advise the
at the age
client.
of 6 months, his mother ran away to Silchar, and when when she came back,
So
after
she
3
came
months,
back, so whatever,
after 3 months.
that doesn't stop her from being a mother. Mother is a mother. She can have some problem, but now she's fighting for the child. She's willing to look after the child. The child is only 9 months. So you talk to your client, okay, see if
Yes,
you
madam.
can
I may,
leave the
Lordship.
matter as it is, let the child grow up, then you can see, look at the mother, see whether she's going to be a fit mother or not. A child of 9 months. Okay, see,
Lordship.
talk to your client,
yes, my lord.
If I may, with regard to that particular issue, Lordship, if my client is not willing to refer the matter
No,
to the local Adalat, Lordship,
maybe not in the Lok Adalat, but whether the petitioner wants to pursue the matter or not also, let her talk to her client. Whether
Lordship.
the instant case, then you can settle it.
in my
Not
humble,
in the necessary in the Lok Adalat, let her talk to her client also.
in my humble
Isn't it?
opinion,
She's
simply
the
one point.
petitioner. So if the petition doesn't want to pursue the writ petition, whether then we don't have to look into the maintainability of the writ petition also. Maybe she wants to withdraw also. Give her some time. Talk to your client.
Yes, my lord.
9-old child. Mother is willing to look after. Okay, whether there is any point in pursuing the matter also. Then on and off, I keep saying they are not some material that you have to fight over like an object. Okay, see what it will be the best interest of the child.
Yes, yes, my lord.
Ms. Jacinta so learned counsel for the petitioner is present along with Mr. C. Nalunsiama, learned counsel for the respondent. The learned counsel for the petitioner has prayed for time since she was not able to contact her client. In view of the above, list after 1 week.
After 2 weeks, my lord.
Lordship, the matter is now pending before the trial court. And next Wednesday is the court date. So it's somehow an intentional delay of the proceedings, Your Lordship, even though the stay order is not granted.
What is before the trial court?
The trial court is for it an objection of the guardianship application, Your Lordship.
Oh.
So they may raise the objection, Your Lordship, in the trial court. It's very easy, Your Lordship. So there's plenty of judgment
So see whether you want to withdraw your writ petition or not. Okay, that's the main thing. List in the next week on, we'll make it a Tuesday.
After 1 week, my lord. Because till that also I could not raise my client. And
Okay, so let's see
I
if
have
they
to
can.
try.
Okay, list in the next week. List after 1 week.
Yes, my lord.
The child is with you, isn't it?
with me, Lordship.
Leave it. Okay, just leave it. See if you can settle. He might not want to pursue the matter also. So,
Lordship.
Much obliged.
Oh, blank, Lordship.
Item 7.
May it please your lordship. My lord,
yes.
this instant appeal has been filed challenging the order dated 11/2/2025 that was passed in CMA number 159 of 2024 arising out of declaratory suit 12 of 2013, wherein the instant respondent number 2 was allowed to substitute the deceased respondent number 1 in the declaratory suit that has been filed by the deceased respondent number 1 herein. The brief story is that, my lords,
See, wait, I've just looked at the last court's order.
yes,
He may be given a week's time to examine the provisions under which a first appeal
yes,
against an order can be filed.
my lord. My lord, in this regard,
Let's see how.
I am not covered by Order 43, my lord. So that is why I have come under Section 151. I've invoked the inherent power of this court.
Which is the order? No, I don't think so. Which is the order against which you have approached
It
this
is
court?
Roman 11. Roman 1 and Roman 11 is the operative portion. This is an order passed in CMA.
Roman 11?
Roman 2, I apologize.
2.
Roman 2, I apologize.
This is allowing an application for substitution
Yes, my lord.
in the light of Order 22 CPC, Red Bit 151 CPC.
My lord. The instant respondent number 2 has filed a substitution application in this declaratory suit, which was allowed, provided being ordered. And I am not covered under Order 43, CPC.
Let's see. CPC. No, but under, if you come under FAO, it is a first an appeal against the first order, isn't it?
Yes, my lord.
So, just because you don't come under 43, does that mean you can come as an appeal? So you have to check. There must be a reason why this thing, I had not looked at this
No, no.
before.
In the last court, it was discussed that whether I have come under Order 43 or not. And I was directed to examine whether I can come under Order 43 CPC. However, on careful examination, my lord.
Okay,
my
let's
case-
read Order 43.
my lord.
What are the orders that can come under Order 43?
yes,
Huh,
ma'am.
40, wait, let me just. This is 43. Appeals from orders, yes.
Yes. An appeal shall lie from the following orders under the provisions of Section 104, namely, A, an order under Rule 10 of Order 7, returning a plaintiff to be presented to the proper court. Now, I am not covered by this. And under Rule 9 of Order 9, rejecting an application. This application, my lord, this was already allowed. And hence, I am not covered by this subsection C. And D, an order under Rule 13 of Order 9, rejecting an application in case open to appeal. The application that was filed by the instant respondent number 2 hearing was already allowed. An order under Rule 21 of Order 11, 1. An order under Rule 34 of Order 21, on an objection to the draft of a document or of an endorsement. Even this, my lord, I'm not covered by this order. J, an order under. Rule
Anyway,
yes.
okay, come down, an order on refusal to leave. Okay, these, you're not covered by that,
Yes, my lord.
then?
I am not covered by all this, what has been provided under Order 43. That is why I have invoked the inherent power of the Honorable Court.
Okay, let's see 104, section 104.
Orders from which appeal lies. Your Lordship has it. 1. An order shall lie from the following orders and save as otherwise expressly provided in the body of this code or by any law for the time being enforced from no other orders. Number 2, an order under section 35A, 3. An order under section 91 or section 92 refusing leave to institute a suit of the nature referred to in section 91 or 92, as the case may be. An order under section 35, an order under any of the provisions of this code imposing a fine or directing.
That's not, you're not
Yes,
covered.
yes, my lord.
Any order made under rule from which an appeal is expressly allowed by the rules.
So, my lord, there is
So you have invoked which provisions, let's see?
inherent power of this honorable court as well as section 17 of the Mizoram Civil Code Section.
Simply 151. Anyway, we'll have to look at this. This is the stage where you have to issue notice.
Yes.
And the maintainability of your present appeal in its form and style will be left open. I think because we'll have to look into this, let the opposite party also do their homework.
And my lord, I have filed Connect IA, wherein I have read this honorable court for staying the proceedings of the declaratory suit 12 of 2000.
We'll issue notice first. I heard Mr. Tila Zakima, learned counsel for the appellant, who has filed the instant first appeal against the order dated 11/02/2025 under section 151 of the Civil Procedure Code 1908, read with section 17 of the Mizoram Civil Codes Act, 2025, wherein the learned civil judge, within brackets, senior division -6.
Yes, my lord.
Had allowed the prayer of the applicant for substitution of the plaintiff by her son in light of Order 22 CPC, read with section 151 CPC. Full stop. This court finds it fit to issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. Let's stop. List after 3 weeks. Then, first of the next line, the maintainability of the instant RFA in its present form and style shall be kept open till the next date. Yes.
Item 8.
Yes.
Your Lordship, I'm appearing for the respondents 1 to 7. However, I have not yet received any instruction.
Okay.
If I may be given 3 weeks' time to get the instruction.
Yes, Ms. H. Malsomi, learned counsel for the petitioner is present, along with Mrs. Caroline K. Lalungoipui, learned government advocate for the state respondents. The learned government advocate has prayed for time to file the counter affidavit since she has not received the para-wise comments from the government till date. In view of the above, list after 3 weeks.
Yes, Madam. Obliged.
Orders, item 9.
Yes,
Lordship, this application under IA 77 of 2025 is for impleadment of Timothy Jubilee E. Chuova. Notice has been issued to all parties.
okay, so parties are represented.
Yes,
Any written objection to be filed?
My lord, I'm representing a respondent number 1 to 5.
1 to 5. How many respondents are there?
1 to 5, my lord.
So he has prayed to be pleaded in the RFA.
Yes, my lord.
Any objection?
My lord, I have not filed any objection, but I would like to raise one verbal submission, my lord. Just one. If I may take it to the main appeal, my lord.
Main appeal.
Yes, my lord.
Ah,
Page number 20, my lord. My lord, here we can see in the cause title.
that's why,
Yes,
since he was not a party,
my lord, I will.
he is praying that he be allowed to be pleaded.
Yes, my lord, I will come.
Ah,
Please, my lord, if we look into the plaintiff number 1,
oh,
and it's written Sri VL Wabzawa
oh,
and son of so and so, LSC number so and so 626 of 2005. And my lord, this is the annexures. This is the annexure annexed in the RFA. Memo of appeal. My lord, this is the petition filed in the senior civil judge. And if we look into the annexure, that is in page number 37. This is quite confusing, my lord. Here, the first applicant, the plaintiff, it's VL Wabzawa. The LSC number is 626 of 2005. But here the name is written Hipei, my lord. And plaintiff number 2, that is,
so what do we do?
my lord,
You are confused, you're also confusing us, so you could tell us.
no, my lord, in this these plaintiffs from the senior civil judge, the original court, my lord, 1, 3, and 5, the LSC that has been annexed in this memo of appeal, my lord, their names have been mutated. So at this stage, for impleadment, my lord, it is quite late for now, since it was not impleaded in the trial court, in the
That's
original
what.
court.
So you file a written objection if you're going to object in the IA. Okay. And then we'll see what provisions of law under which section have you approached this court to be pleaded.
Lordship.
Is it allowed?
I have filed this application
Under section?
under Order 1, Rule 10, Subclause 2.
So you see order 1 rule 10 subclause 2, whether he can do it or not. Okay, that's the written objection. Not, because we already know that he was not a party before the learned trial court, but now he is prayed to be pleaded in under a certain provision of law. So you look at that and see whether you're going to file a written objection or not. Okay, yes. Heard Mr.
Lordship, at this stage,
Uh,
opportunity has been given to the respondents as to whether they'd like to file any objection.
How
within
many
the-
times?
Within the period given. So within that, they have not filed. And even today, he's saying that Land Council is
No,
submitting that he's
no,
not
the
filing.
notice was issued,
Yes.
okay, on 16/5.
Yes,
Then, notice was, and then it's been listed again the second, this is only the second time. Well,
Yes,
now
yes,
they are represented. Now, the respondent is represented today. So we'll give them a chance to file
No,
the
even
written
earlier-
objection.
Even earlier, they were represented. The only party that has not been represented is the newly party sought to be added.
Sought to be added.
Yes.
So, we are saying whether they were going to file a written objection or not. Now, the party to be newly impleaded, the person to be newly impleaded,
Yes. That will not cause any, prejudice to them, because it is on the basis of their own plaints that they have stated this land has been purchased by Srimati so-and-so, and has been transferred in the name of this person.
Anyways, let's
this
see,
is their
so
claim.
impleadment, you want to implead Jubilee as what? As a respondent?
As respondent number 5A, because. she
Okay,
had
so
purchased-
notice has been issued to 5A?
Yes, yes.
Then we'll have to wait for her to be present also. If we have
No,
issued
see,
notice,
She was issued, we have filed, affidavit to the effect that we have served personal notice on her.
Dusty?
Yes,
So where's that?
Dusty is there in connection with 76,
What's 76?
IA 76 of 2025. It is connected with this main RF.
So in the impleadment application, we have made her a party or no?
No, not yet. We cannot make her
Yeah,
party.
okay, because she's not impleaded yet. So now, the other respondents, it appears from his submissions that he wants to file, he objects to her being impleaded, okay? But the way he has presented this thing, I think it would be proper if you study the section of law and see whether he is allowed under, the person
It is
can be
clearly-
allowed under Order 1, Rule 10(2).
Yes, Your Lordship.
Okay. Then
My humble
file a written
understanding-
objection.
my
Because
humble
what he has pointed out is that she was not a party before the trial court, and therefore,
That's true.
that's why you have filed this thing. So
Yes.
let him come with some objection.
May I just take a lordship to the provision of law? For the Order 1, Rule 10,
Yes.
Subclause 2. Court may strike out or add parties. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary, in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. Here, it clearly spells out
The court, while trying the
yes.
case, isn't it? But
Either upon
before
or
the
without
lower
the
court, it
application.
were not.
either upon or without application,
Strike
and on
out-
such terms as may appear to the court to be just. Either all the
That before the trial court, while hearing the matter, if it
Yes.
says this, but this is the appellate
this
stage.
is-
This is an appeal, we have not heard the matter also.
The lordship is a continuation of the
So
trial.
the appeal, so now the court doesn't know whether it should be struck off or added, and therefore there's, the opposite party is there, they're going to help the court also
At
by
this
filing
stage-
any written objection,
Yes.
isn't it?
Yes.
Not at this stage,
At
huh?
this stage, Your Lordship, why we have impleaded, we have sought for impleadment is that Srimati Zubili Ichwaha, who had purchased the land in issue, the landed property which has been disputed, it is stated that she had purchased it and they have enclosed the LSC in the name of Srimati E. Chauhan. And now construction is going on. Construction of RCC building is going on the land, the suit land. And this construction was based upon the judgment, the impugned judgment and order. Now, after the filing of this appeal, she continues. And we have earlier approached this honorable court by filing IA for issuance of interim injunction in the absence of Jubilee Chauhan as a party. And what has been stated, Lordship, if I take a Lordship to the orders passed by this honorable court, at page 40,
Page 40 of what?
40,
Of the,
47, Lordship.
what, page 47 of the impleadment application? Is it?
Page 47 of the IA 76.
Okay.
This an application under Order 39 Rule 1, read with Section 151 CPC. It's, may I read?
Read the operative part, it's a long order.
Let me read from paragraph 5, page 49. The Learned Counsel also submits that, in fact, it is not the respondent number 5 who is making the construction, but Srimati Jubilee E. Chauhan, to whom the land was sold. He submits that since she is not impleaded as a party to the instant application, no effective order can be passed. He further submits that the doctrine of lease pendants has not been raised in the application, and therefore submissions made by the Learned Senior Counsel in this regard beyond the pleadings. He further submits that the Transfer Property Act 1882 also is not extended to the state of Mizoram, and therefore the same is not applicable. The submissions made by Learned Counsel for the rival parties have been considered. A discretionary power has been conferred upon the courts under Order 39 Rule 1 CPC for grant of temporary injunction. The same can be granted by the court upon being satisfied that there is a prima facie case in favor of the applicant, irreparable injury likely being caused to the party concerned, and there being balance of convenience in favor of the applicant without delay, and all alleges all these factors should be available to attract the grant of temporary injunction. However, in the instant case, the respondent number 5 is said to have sold his land to Srimati Jubilee E. Chauhan, and as admitted by the parties, constructions on the suit land is being made by her. She being not a party to the instant application, it would not be possible for this court to pass any effective order of restraint indirectly through another individual. The Learned Senior Counsel does not deny that transfer property is not extended to state of Mizoram, however, submits that principle can be applied. Even if the submission is to be accepted, the fact remains that the application made by the applicants is for grant of temporary injunction without making the person undertaking the alleged construction as a party respondent. Such being the position, a general or universal order of restraint cannot be passed in such a manner as being sought for in this application. Application therefore is rejected. Lordship, that is the situation under which we have to approach this honorable court again by seeking impleadment of the said person who has been making construction. And now another application under Order 39 Rule 1 has been submitted again. Your Lordship, if I take Your Lordship to page 51.
51 of
51 of the said application.
IA,
Yes, this 76 IA.
IA 76, page
Page 51.
51.
Yes, Your Lordship. There are 4 photographs which we have shown to the Honorable Court, even on the earlier occasion. On 28/4/2025, These are the photographs taken. And subsequently, after rejection of the earlier application, we had taken yet another photograph at page 52, Annexure 4. These are developments that are going on. And
This is which place? Located where?
located at World Bank Road,
Okay, World Bank
World Bank
Road.
Road, just below Veng Huai. So, Your Lordship, under the given facts and circumstances, there is no other option but to seek for impleadment of the said person who has been making construction, because her name has been reflected in the plaint by the respondents themselves in the plaint during the suit. During
You're saying
proceeding of
that,
the suit.
okay, so the dispute is over this land, is it, this
Yes,
property?
yes. And they have, this particular person, Srimati Zubili Yichua, she did not approach the court as a plaintiff. The person from whom she had purchased the land had approached the honorable court by filing the connected civil suit. So there was something like hide and seek in this case. Now that we have seen what they have put in the plaint, and we have seen the development of the land, how they have, how Srimati Chua has made construction over the suit land. Now, since she was a third party at that point of time, even till that date, she has been making construction, even though it is a Lordship, if I take Lordship to page 53 of this application itself, we have on 8/5/2025, the appeal was admitted, and the impugned order has been stayed by the order
Okay.
at page 55.
What is the order of the senior civil judge that was stayed?
Order of,
Just of the order?
yes,
What has been stayed?
the order at page 13, Your Lordship.
1-3.
1/3, yes.
Oh, this is the order,
This
the
is the order,
operative
yes.
part?
Civil suit number 40 of 2014.
Yes. So the operative part of the order which has been stayed is what?
Operative portion. At page 44, it is indicated that the suit is thus decreed without cost. The competent authority, that is the Land Revenue and Settlement Department, shall, within a period of 3 months, make necessary rectification with respect to the overlapped portion of the LSCs of the plaintiffs by that of the LSCs of defendants number 1 to 4. We are defendants 1 to 4. Additionally, the competent authority may, since it had been found that LSCs of defendant numbers 1 to 4 are also valid at this present stage, explore alternative remedy by means of allocating alternate lands to defendants number 1 to 4, if after proof of verification that the conditions and mode of issuance of LSCs to defendant numbers 1 to 4 was done following due procedures of law. This process shall also be completed within 3 months of the date of this judgment and order. And also,
So you also say that, here this thing, order is also kind of in your favor, alternative plan. So you don't want
that
any
is-
alternative plan, you want the
That
one?
is the finding which has been arrived. But our case is that there is no overlapping. The question of the lands
Okay.
of the
So you want the
defendants being
existing
shifted-
land?
Yes.
Okay.
Defendants, the land of the defendants who are the appellants now, being shifted to other alternative site. would
You
not
are
arise.
unhappy with that?
Yes, we're not happy with that.
Okay.
And in fact, prior to this, there are two periodic patas adjoining to each other. One belonging to the father of those plaintiffs, the other belonging to the father of the defendants. There was never any conflict in respect of those two P-patas. And Your Lordship, when LSCs were issued, there was no dispute over those lands also. Thereafter, the World Bank Road, the Aizawl Bypass Road was constructed, and the plaintiffs, who are the respondents now, they are inclined for having a land just on the roadside, and they have tried to dispossess the plaintiffs, the defendants of the ownership of the said lands. And the suit was filed, and the suit was disposed of in such an illegal manner. And under the
Okay,
given
anyway, so
circumstance,
that's the appeal about, isn't
yes,
it?
that's the appeal
So,
about.
Though,
And now-
though it's, the court says that you also have valid LSCs, but it is not over the land which you are saying we want that land, isn't it?
That's true. Your Lordship,
So now the construction, the photographs which you showed me, it is
Yes.
over the disputed
over
portion.
the land of the applicants, over the land of the applicant, defendant number 1,
According to you.
John Maya. And they said, there's no dispute about that, about the location of that particular LSC. But the dispute is that it has overlapped. It has overlapped the LSC of the plaintiff, number 5.
But
who had
if the
sold-
plaintiff is also having a valid LSC, that means what to do?
That is where the dispute lies.
Both of you
Now-
have valid LSCs over the same plot of land.
Yes. Now,
So
what
one
the-
have to say, okay, give me alternative, otherwise what do we do?
now, Your Lordship,
So you're saying his
our case is
LSC
that-
is also valid, yours is also valid over the
our case
same.
is that
One
there
has
is
to
no
be
overlapping.
invalid.
It is
Okay.
only the manner in which it was taken, measurement. The kind of measurement which was taken at the time of verification was faulty. And as a result, the learned trial court has come to wrong finding. So while the suit was in the process or in progress, the fact that the plaintiff number 5 had sold his land to Srimati Zubi Lee Yi Chuao was not
Okay.
properly highlighted. And
Yes,
now,
I've got your point, huh?
just because defendant, respondent number 1 also had transferred his land to Mr. Hipei, would not deter this honorable court from impleading the respondent number, Srimati Yi Chuao as respondent number 5. Because it is only Srimati Chuao
Okay,
who is
yes.
making the construction. No one is doing anything over the suit land at this stage. That's why, Your Lordship, the interference of this honorable court is called for even at this stage. Let status quo be maintained. Let them submit the whatever objection they have in the meantime. If they want to contest that application, let them file their objection. But at this stage, let status quo as on today be
But
maintained.
status quo, have you mentioned that in your application?
My Lord, I have
In the
sought for
IA?
it.
In the IA,
Yes. At page 10, in that interim, to maintain status quo as on today,
page 10 of what?
page 10 of the application, 76.
We're dealing with 77 now.
That is in respect of impleadment.
Okay, so now, yes, concerning the impleadment, any written objection or no?
My lord, as I've mentioned, that this is quite confusing if you look into the annexes.
The confusion was made by themselves only.
My lord.
So
this-
that confusion is not there. So
My lord.
no objection letter also be impleted, and then we'll see.
My lord, in order to implead also, the court have, in my humble opinion, the court have to be very sparingly and in exceptional cases that implement should be given. So in this case that I have just pointed out earlier, that one in the senior civil judge,
I don't
plaintiff
understand
number
all
one-
that, frankly speaking.
My lord,
Now,
plaintiff-
it's just whether you want to implead this person, if you are going to file a written objection because you have made the opposite party, okay? The respondents in the impleadment application. So we are being fair. If you want to file a written objection, you can file. If not, we will allow and make them a
my
party.
lord, I will file the objection.
We'll make it a short date.
Yes, ma'am.
Okay. And then you can point out the complication, which we say you find it very complicated. Make it in a written form. This
madam.
thing like this, I don't understand, isn't it? Now, in the interim injunction,
My lord, in that regard, if I may just.
but here Jubilee's made a party. The main injunction will be, so we'll make it a short date. Then if no written objection is filed by the next date, then the highway will be disposed of. Okay, we'll make it like that.
Yes, ma'am.
Heard Mr. Sila Ramzawa, learned senior counsel for the applicant, assisted by Mr. Ivan Lalpatsaya, learned counsel. Full stop. Also heard Mr. Ricky,
J.H. Ricky, ma'am.
J.H. Ricky, Lalpatfela, learned counsel for the opposite party, who has prayed for time to file his written objection. The learned senior counsel has expressed urgency in the matter. In view of the above, the learned counsel for the opposite party is to file their written objection, if any, by the next court date. Fix on 1 week?
Yes, my lord, 1 week.
Give me a date.
Lordship, today is 23rd.
30th.
29?
Okay, fix on 29/5/2025. Yes. Even if you say status quo, it's going to be against this Julie, so it's a bit difficult right now. Yes.
Item 10.
Lordship, even in that 76, same order.
76 is interim injunction.
Yes.
Okay, in that also by the, heard Mr. So-and-so and so-and-so. Now, Ricky will be representing respondents number,
Yes, represented
Two?
respondent number 2.
1 to
OP number 2.
okay, opposite party number 2, isn't it? So only opposite party number 2 can file their objection. Or Julie also.
Jubilee.
But
she
Jubilee
has
is
been
not a
notified.
party yet, so.
Yes,
Not a
no.
party yet.
So far as Jubilee is concerned, she has been shown as a party in 76 of 2025. Because the
But no order
injunction,
can be passed against her because she's not a party yet.
Yes,
the
my lord.
injunction application has been made directly against her. So she has been made a party. Otherwise, in the absence of being,
No, I think the IA has to be disposed of. Then respondent number 2, if you want to file a written objection in the 76, okay, Mr. So-and-so, along with Ricky for opposite party number 2. You can file a written objection in the IA 76. Jubilee, let's dispose of the impleadment application first. Once the impleadment application is disposed of and she's a party, then she can file her written objection in the IA. I think the same observation was made by this court.
the observation has been made by this
How can
court.
we pass an order against her, isn't it?
Yes, Lordship,
So we leave it at that. Let the opposite party number 2 file any objection, and then in the next date, the impleadment application has to be disposed of.
And Lordship, now that has been notified, the opposite party number one, Srimati Jubilee, has been notified. Notice has been issued to her.
I know that shouldn't have been anyways, because she's not a party. Anyways, so leave it at that. If she files, she's not represented today also. So you leave it at that.
And,
Written objection by the opposite parties, if any, in 76. No, 77. Okay. Both of them are 76 or
No,
77?
76.
In 76. Okay. And today's
77.
matter is 77.
Impleadment is 77.
77. So 77 within 1 week.
Within 1 week means the same
On
day, that
on
is
the 20, which date did we fix? On
29.
29th. Okay. So let's finish the impleadment first. In the meantime, if you file, since notice has been received to you in 76, you can always file. There's no distinct bar in filing a written objection in that also.
Now that she has been given notice, whether it will be appropriate for her to engage a counsel?
I don't know, just leave it at that. She's not here also, so just leave it. Don't
not
worry
here,
about her. Leave
yes.
her, let her be. Okay. We'll dispose of the impleadment first and then we'll see.
Let's say in
Yes.
that case, let the date be fixed a little earlier because that 77, that is regarding impleadment. If only after impleadment is allowed.
So impleadment, since this, since 76 is attached with 77, whenever 77 is listed, 76 also will come. It will be listed, it will come along with that. So we'll dispose of 77 first. In 76, since notice has already been issued, let that be there. If they file their written objection in 76 also, let it be there. But we'll dispose of 77 in the next date. Okay, come prepared, if any. Okay, then we'll hear and dispose it off in the next
Obliged,
date.
my lord.
Yes.
Item 10.
Please, Your Lordship.
Yes.
This is a criminal appeal, my lord, state appeal.
Ah.
The lead counsel being Miss Mary, and she's indisposed. If the matter can come up next week, my lord.
Notice is also not served upon the sole respondent. Here it says that additional PP, Mary is allowed to take steps by dusty service. So affidavit is also not there, isn't it?
Yes, ma'am.
Okay, Mr. Samuel, this thing, Shweta, no, but you are not this thing, learned
Just
counsel.
mentioning on her behalf.
Learned counsel, appearing on behalf of Mrs. Mary Alkiante, learned additional PP, submits that the learned additional PP is not able to appear, being indisposed. In view of the above, list after 2 weeks.
Obliged, ma'am.
Hearing item 12.
None appeared for the parties on call. List, let me see how many times this matter has been listed. Okay, list after 2 weeks.